Introduce your name, state your name, introduce yourself for the committee, and then we are very interested in your experiences with the Court of Judiciary.
Yes, my name is Connie Reguli. I am a licensed attorney in the state of Tennessee. I returned to law school kind of late in life. My family were the owners and operators of the New Orleans Manor Restaurant, which was kind of a historic restaurant in Nashville for 40 years. And I went back to school, became a lawyer, and really became a lawyer to serve justice. And I had quite an experience in life before I got there. I first went into law being a district attorney in Davidson County, practicing under Torrey Johnson for about 3.5 years, primarily in domestic violence. I then went into private practice. My practice focused in family law. I'm here before you today as kind of the involuntary heir apparent to John J. Hooker and the unofficial poster child of retaliation in the court system. And I, however, look at this problem a little bit different than he does. John Jay and I just love to hear him talk, and I appreciate his constitutional knowledge. And he views a lot of this from the top down, and I look at this from the bottom up. And what you've heard here today, and hearing the testimony of Ms. Gaugy and Ms. Wiley, you could put their story on 1,000 faces. It's real important that you understand that in Tennessee, and you can get this from the AOC statistics, about 70,000 cases a year are family cases. And that's either divorce or child support or paternity or adoptions. And all of those people have at least 2 parties and have children. So you're talking about affecting the lives of thousands and thousands of people, and the dollars, and the dollars to the litigants, the dollars to the state. This is a huge problem. Now, let me tell you about me. I first practiced in Davidson County. I went down to Williamson County in about 2005 and opened a small family practice there. I started suffering a little bit of, let's say, irregular behavior in the courtrooms. The first thing that happened was in open court, when I had asked legitimately for some relief for a client, the judge called me a jerk. That was just sort of the first thing. I was a bit taken back. I brushed it off. I blew it off. I walked out of the courtroom. I continued to represent my client to the best I could. Within the next year, I had other kind of small things that occurred. And within about a year, probably not even a year later, I had a full-blown trial in front of that judge. While I was making objections on the record, which by Tennessee rules of evidence I am allowed to do, trying to make objections on the record to hearsay, relevancy, and the judge finally stopped me flat in my tracks, told me to be quiet and sit down and pretend that this wasn't a trial. He then took over the examination of the witnesses for the next 70 pages of transcript and ruled against my client. We started to take it to the Court of Appeals. Prior to getting to the Court of Appeals, we actually negotiated with the other side what we wanted, but it cost thousands of dollars. Let's move on up to 2007. Same judge, same courtroom, different faces this time. I'm representing another client. The judge appoints his own counselor, communicates ex parte by email communication with his counselor at midnight on his...
Judge appoints his own counselor. What's that mean?
Judge appointed a counselor by his own selection to serve as the appointed counselor in the case.
Okay, so the appointed counsel for one of the parties, or guardian ad litem, or
not a guardian ad litem, not under any statute, not under any particular rule. Just says this is going to be the therapist for the parties.
They appointed a lawyer to be the therapist.
No, therapist.
Okay.
I'm sorry, counselor therapist. I
okay,
need to be
I'm
careful.
With you. Okay, I understand. Okay.
So he appointed, had gone into the back room, gotten a name, comes out. He then goes into ex parte communication by his own personal email, does a show cause order against my client and somebody who's not even a party to the case to threaten to put them in jail. That's when I put my foot down and I said, no more. This isn't happening. And within the next 6 months, that judge accused me of advising a client to violate a court order, held me in contempt of court. I tried to do a Rule 10 with the Court of Appeals. I tried to do a Rule 10 with the Supreme Court, which means, and for the attorneys who know, that is going to the Court of Appeals and saying, I need extraordinary relief. I need for y'all to step in with your supervisory powers and take control of what's going on, and it was denied. I asked the court to recuse himself. He refused. I sent a fax, then a memorandum to the AOC saying somebody needs to step in and take a look at what's going on. They refused. The judge appointed the district attorney to prosecute me and refused to have a bond hearing, locked me up, handcuffed me, had me sent out of the courtroom, taken to the sheriff's department and bonded out.
Prosecuted you for contempt of court?
Yes, because he said in his own hearing that I had advised the client to violate a court order. He said that my client testified to that. He did not. He did not testify to that. There was a transcript that showed that he did not testify to that, and he continued to hold me in contempt. Ultimately, that case, I appealed it and won. However, that took 10 months, and in the meantime, in February 2008, I came to the House Children and Family Affairs Committee with Ms. Janice Johnson and another litigant who had been in the same courtroom suffering the same type of just abuse in the system. And again, I'm saying I'm looking bottom up. What is going on and what can be done and why it's not being done? Because, as Mr. Hooker says, nobody's going to do it. No attorneys are going to do it because they will suffer what I suffered. So February 2008, I came and spoke at a House committee meeting, and I told them there were problems. And within the next 3 months, there were 3 judges in the same county filed complaints with the BPR against me. And then I came again in April and spoke again to the House committee. At that House committee meeting, Representative Mike Turner finally said, when are we going to start impeachment proceedings on this guy? I've heard other complaints. Within the next 4 weeks, or June, so it might have been 5 or 6 weeks, there was an announcement that the judge was going to resign. There were, I know of, at least 4 or 5 complaints filed with the Court of the Judiciary in January 2008. I filed my complaint saying that he had wrongly accused me of contempt. I filed a complaint, assisted 4 or 5 other litigants in filing complaints that he was trying to hold a non-party in contempt of court, that he was communicating ex parte, and each one of these sat for 8 months. And then I got a nice letter from the Court of the Judiciary saying he's no longer on the bench, so we no longer have jurisdiction. Now, after that, I thought, well, you know, I don't think I'm the only one who filed complaints. And so I started asking around. I started following up with people who I knew who were making inquiries. I found at least 2 other legitimate attorneys. One attorney in Murfreesboro, when this judge had refused to recuse himself, when that attorney had the judge under subpoena to appear and testify in a divorce case because he had had an affair with one of the parties. There was another attorney who had filed a complaint against the judge because he had been dishonest on his statement of interest and had failed to disclose that he had a monetary interest in a building in which the attorneys that he used to be a law partner with. And he failed to disclose that. So there were several complaints.
Let me stop just a second. A judge, as most judges were lawyers, practicing lawyers before they were judges. And your point that you're making was that a judge still had a financial interest in the building of which he used to be a former partner with a law firm. And how's that relevant? Tell me what.
Because he had, that was a financial interest with those lawyers, and it finally came out that it was. So
your point is that the lawyers from his firm shouldn't be practicing in front of him while.
Right.
Okay. Well,
but let's just go back to the form. When you run for office, you have a statement of interest. Your statement of interest, you're supposed to list any financial interest that you have.
And I filled out a ton of those forms, and I can understand how they're vague and ambiguous, and sometimes you can have an oversight. And so, but most judges that I know, most who have practiced law, like recuse themselves from from hearing any cases with their former law firm. Is that what this judge did?
No, he did not.
So he continued to hear cases of his former law partners?
Correct.
Okay. Even without a financial interest, I believe that's inappropriate.
Right.
I don't think we need a financial interest to be able to say it's not. It's just, again, what I'm hearing more and more of, and this issue we've talked about before, is there's an appearance of impropriety, and if there is, a judge should recuse themselves, and that's an issue I think needs to be hammered home at our next judicial conference, that take this seriously. And if there's appearance of impropriety, there has to be done within reason. But otherwise, we can't conflict out every judge for every pot because they go to church with so and so. There are small towns and communities where judges know everyone, so it's not an issue of who you know. But when we have something as blatant as allowing your partners, maybe new lawyers that come to your firm, the former firm, that would be different. Allow them to practice, but if I have 5 partners and I become a judge, those 4 partners shouldn't practice in front of me. That's just common sense. They shouldn't do that. Not that I can't be fair. I think you can. The citizens have spoken. They've elected you, but it creates the appearance of impropriety, and I think our judiciary should be above that. And as Senator Jackson says, we need to take the high road, and that's obviously been avoided in several cases here that we've heard today. So
well, and here's the problem that comes, again, looking at this from the bottom up. This was going on. The judge was sitting on the bench. He was continuing to hear cases in which his partners and other attorneys are afraid to say anything because they will then be prejudiced and biased and retaliated against. And that happened because I complained in one of the cases that I had that this attorney should not be going in front of this judge, and I was retaliated.
Did you make those complaints to the Court of Judiciary again? And we'll go back to I think we've allowed some latitude to get to where you are, so let's get to the Court of Judiciary now. Did you make those complaints to the Court of Judiciary?
That one wasn't, but these others were that I talked about. There were at least 5 complaints filed about the wrongful finding of me in contempt, the ex parte communication, the attempting to hold non-parties or threatening to hold non-parties in contempt of court.
And this is the same judge you said ultimately resigned, though?
Yes.
Okay. I guess it raises a couple questions, members. One would be, I don't know what the jurisdiction of the Court of Judiciary is if the judge is no longer on the bench. I don't know if that would be appropriate to allow if their jurisdiction terminates with resignation. I don't know if it'd be appropriate for us to consider allowing them to continue a case if something's been done wrong, just in case to create a record so that other judges can see there's certain things you can't do.
Well, and let me just add one thing to that. Here's part of the problem with that. When they report their statistics at the end of the year, for that year in, part of the reported statistics were, I believe, 7 complaints were dismissed because the judge retired. So again, this gets down to transparency. So why did those judges retire?